Again. Today we're going to talk about the subjects of juries. And I'm going to do lesson 21 and 22, this question of juries and how these juries work and why we don't have juries in the United States anymore, and how or what are we going to do about returning the jury to the courtroom and the grand jury to investigating our public officials, or the subjects that we want to talk about in these next two lessons. So just taking a look at lesson 21, we have a thing called a grand jury. Do you know what a grand jury is, how it functions, where it works, what the powers of the grand jury are? A petite jury. Have you ever heard the term or the word before? Is it 6? Is it 8? Is it 4? Is it 12? Is it 40? Is it 90? How many members to a petite jury? How about a state constitutional jury? Instruct juries, in special juries, coroner's juries, sheriff's juries. And what does the word jury mean? How did we come to get a jury? How far back in history do juries go? And have you ever served on a jury? And do you know how to get on a jury? Or are you one of those that gets bumped off every time when they start voir diring the jury? That's where we come into jury selection. You know, whether you're the defendant or whether you are a prospective juror, you can be extremely valuable as a juror, in addition to being knowledgeable in how to select a jury. And then jury instructions. Probably the most important single thing we're going to learn to do in this particular segment on juries here is to learn how to file jury instructions and what jury instructions are. And I'm going to give you a list of those, or some samples of them, and show you how to put those in, because winning and losing depends upon jury instructions. In lesson 22, I want to go on here for a moment. We're going to talk about hearing the law. Does the jury have a right to hear and decide the law, or only the facts? And then juries to hear the facts, hearing the evidence, and then what is the highest judicial authority. So I may skip back and forth, but this subject, you know, is so important, it's like motions. If you can't write motions, briefs, affidavits, and file paperwork, you cannot function in the courtroom. Now, personally, I've never won a case in front of a jury, and in 33 times out, I haven't lost a case yet. I'm on the verge of winning 4 more. I think that by August I'll have 4 more victories, and I don't think any of those are going to be from a jury verdict. It isn't that I'm afraid of juries, it's that juries are citizens, and citizens are products of our educational system. And when you have a person who's gone to the government schools, he's going to learn and come out of that government school preaching, teaching, and believing what the government has told him. I know I went to the government schools, and when I came out, I thought driving was a privilege. And I've been told all my life that jurors could only hear the facts and not the law, and that the law would be decided by the judge. And in the last few years, I've heard some new terms that I had never heard before, like jury nullification and jury lawlessness. Have you ever heard those terms? Well, if not, I'm going to show you some Supreme Court cases and decisions and some law school professors that seem to know and understand jury nullification and what the function of the jury is, and how the judicial system works with the juries, and what we really have without the juries. And I want to take you into the Macon and Wilson cases pursuant to grand juries in our Fifth Amendment and Rule 6. There's so much written on juries and so much said, and I think that people have heard the word a lot, and maybe a lot of you have served on juries. And I think when you get down on the bottom line, you'll find out, gosh, how could I have been so ignorant about the jury system? And I know that in the last couple of years, I found out just about all I know about juries in the last year or two, 2 years at least, and boy, in the last year we've really done some research on it. And we've put together 2 books here on juries that must compile about 20 cases. And so let's just take up a subject. Let's talk about a grand jury for a moment. In the state of Idaho, to my knowledge, and I've heard this bandied about, the last time we had a grand jury was 18 years ago. Now, the federal grand juries meet when we have federal cases, and there's 23 members to those federal grand juries. Grand jury meets up here at 550 4th Street, and it's a secret grand jury, which tells me that if it's a secret grand jury, it's probably a government grand jury. And so what we're really faced with then is the old King George syndrome. We have trial by government, and we have grand jury by government, and we have petite jury by government. But at any rate, the dictionary tells us that the grand jury is going to have something more than the regular jury or the petite jury. And in Idaho, I think it's about 16 members to a grand jury. You can have anywhere from 16 to 23 members. Now, I can remember when I was a youngster in Northern California, the grand jury used to meet, and it was composed of doctors and lawyers and businessmen and citizens around our county. And there was, every day, it would seem like in the paper, there was some little piece in there. The grand jury summoned Sheriff so-and-so in, and the grand jury summoned the mayor in, and they would summons the county commissioners in, and they would talk to all sorts of people and do all sorts of things. Because the grand jury has broad inquisitorial powers, and we're going to see that as we read through some cases, and we take a look at what grand juries do. But today we don't see that anymore. The investigating or the investigatory powers of these grand juries are no longer with us. And if the grand jury investigated public officials back in the 40s and the 50s, and we don't have the grand juries today, does that tell you that perhaps our public officials are not being investigated in the way that they once were? And if they're not being investigated today and we're having trial by government, well then, who is it that determines whether or not you're going to be prosecuted for tax evasion or willful failure to file? Is it the citizens or is it the government? And if it's the government, how do they single people out, and what is it that they do to bring you into court? All right, first of all, there's a book written called Born Again Republic. A fellow named Red Beckman, a patriot up in Montana, wrote this book. I don't, as I've said before, push other people's books, but I'm not making a profit off of them, but I'll certainly tell someone about a good book when I hear about it. I would say that Red has probably done more research into this thing of juries and has done more work in educating people in general about juries and how they work, and so good or so well has this worked in Montana that to my understanding in the last couple of years they've had no indictments on tax cases in their federal grand juries, and that in Billings, Montana, the IRS is operating about 4 hours a day, 2 or 3 days a week. And that when people in Montana come into a courtroom, they understand that they have the power to try the law as well as the facts. That Red Beckman has been on television and radio, and he's been lecturing all over the state and telling people about how the Constitution chains down or binds down this government, and he calls it a monster, the government monster, and keeps it in check and keeps it in control. And I think I heard a piece on the news about Red Beckman and about the juries up there in Montana, and that they're extremely unique. And one of the things we need to keep in mind is that Montana is a relatively small state in that it probably doesn't have much over 1 million people, unlike New York or Pennsylvania or California, where you're talking about multiple millions of people and mass media, huge newspapers. People in the cities, I think, may be a little more difficult to reach and educate than people out in the rural areas and the smaller cities. But nevertheless, I think it's possible to tell people, and it doesn't take much to educate a man about a particular subject. It doesn't require 6 hours for me to sit here and tell you that when a citizen sits on the jury, he sits in the place of God himself. And it's a pretty awesome responsibility. Jurors are the highest judicial office in the land. You know, we tend to think that it's the judge that has the highest judicial office, and when we walk into the courtroom, the judges will use terms like, in my court, poppycock and balderdash. When a man walks into that court, that's the citizen's court. It's the place where the citizen gets his redress of grievance, and that defendant in there is claiming his 9 square feet on that courtroom floor, if he knew and understood that, and that judge is nothing more than a crummy referee, and that the judges are the jurors, and it's those 12 jurors that are sitting over there that are going to decide whether or not we're going to let the government punish this man. The government has to come to that jury and say, can we put this man in prison? We want your permission. We want to tell you the story. We want to tell you jurors here what this guy has done, and we want your permission to put him in prison. Have you ever thought about it in those terms? But that isn't the way our juries work, and if you've been in the traffic court, maybe you've seen the judge actually instruct the jury and tell that jury, I'll decide the law, and actually make them take an oath. And I know here in Ada County, the judges in the traffic courts have this little oath. I don't remember exactly the words to it, but do you swear that you'll try these issues honestly and truly, and that you'll obey the court's instructions? And yes, I swear I'll follow all of the court's instructions. And so when the court says, okay, we're instructing you to find this man guilty, well, you've already sworn an oath that you'll follow the court's instructions, and now they're instructing you to find him guilty. What do they need a jury for? Well, the truth of the matter is they don't need a jury. No jury is necessary in any civil law or any civil law case. Any administrative law case, what do you need a jury for? When they give you one of those, that's just window dressing, a little frosting on the cake to make the slaves feel like, well, gee, I'm getting due process of law. So I'd like to recommend that book called Born Again Republic. I don't know what it costs. If you'll write to us here at P.O. Box 9411 in Boise, Idaho, to Barrister's Inn, I'm sure we can get a copy off to you for $3 or $4 or $5. You can call or write and ask. Otherwise, check around and ask in some of your patriot groups. You know, I'm not the only fellow in the world that hears of a good book once in a while, but Red has laid out this jury thing in such a, well, I shouldn't use the word simple because I don't mean to demean it, but I mean the book is written on such a level that a third grader should be able to understand the purpose and the reason for a jury and the protection that the jury affords us. First case I'm going to bring your attention to, let's take a look at Mackin, that's M-A-C-K-I-N, versus United States. That's 117 U.S. 348. Here's a fellow who was convicted, put in jail, didn't have a grand jury. Let's take a look and see what the Supreme Court of the United States was saying about great grand juries in 1885. This case was an information filed by the district attorney on January 20th, 1885, in the District Court of the United States for the Northern District of Illinois. And it was on 5440 of the revised statutes, which are as follows. And this guy defrauded the United States out of something, committed some kind of a crime, so it's a federal case. The information contains 7 counts, which were respectively for conspiracies to commit offenses within those statutes. The substance of the offense is alleged in different forms, and the various counts was the breaking open of a package containing a return by the judges and clerks of the election. So here was a guy trying to fix some kind of an election in the district in the city of Chicago. Well, that's understandable. You know, in Chicago they fix elections up there every day. Actually, that's not a crime in Chicago. That's just normal election procedure. I don't even understand why they prosecuted this guy. So this is in the district court. The defendants were tried by a jury and convicted on March 21st, 1885, were sentenced to pay a fine of $5,000 each and to be imprisoned for 2 years in the penitentiary of the state of Illinois at Joliet in the said district. A writ of error was sued out by the defendants, returnable at May term 1885 of the circuit court. And at the hearing in that court, the 2 judges presiding were divided in opinion upon 5 questions of law, and at the question of the counsel for both parties certified to this court those questions, 2 of which are as follows. 1, whether the crimes or any of them charged against the defendants in the counts of the information are infamous crimes within the meaning of the 5th article of the amendment to the United States Constitution, and whether the defendants can or not be held to answer in the courts of the United States for the crimes charged or any of them against them herein otherwise than on the presentment or indictment of a grand jury. The other question certified related to the sufficiency of the several counts as setting forth any offense and need not be particularly stated. Two questions are going to be answered then by the Supreme Court. An information, is it on an infamous crime, and are they infamous crimes within the meaning of the fifth article, and do you have to have a grand jury? Now whip out your little Constitution book and let's see what our Fifth Amendment tells us. It tells us here that no person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury. Now that sounds pretty plain, straightforward, and simple for me to understand. You have to have a grand jury indictment. And a grand jury is 23 people selected at random from the community, and those people will sit and determine whether or not we're going to try this guy. So the very first contact that you're going to have works like this, or this is the way it's supposed to work. You're alleged to have committed a crime. So someone, it could be Joe Schmedley, your next door neighbor, writes up an information, just writes up some information on a piece of paper, just like this. He takes it to the grand jury and he says, well, old Sam Smith, my next door neighbor, did thus and such and so, and I want him prosecuted for that. The grand jury sits there and says, well, yeah, let's bring him in. So they haul you in and they say, hey, we have an information in front of us, and it says that you did this, 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 and this. Now, is that true? And there's your opportunity to defend right in front of your grand jury, your fellow citizens in your own county. No, I didn't do those crazy things, or yeah, I'm driving on the road without a license, so what? And the grand jury will then say, well, we think that's a crime, or we think that that's necessary to prosecute. Now, that's the common law in action. The civil law doesn't bring you to a grand jury. The civil law brings you in front of a judge, and the judge then gives you what's called a preliminary hearing, and the preliminary hearing takes the place of the grand jury indictment. And it's the prosecuting attorney in your county that decides whether or not they're going to prosecute you. You can go into your prosecuting attorney, we've done this several times in our county, and said, here's my sworn statement, here's my 2 sworn witnesses on this affidavit that this policeman did in fact steal my automobile, and I want you to prosecute him. And the prosecuting attorney will say, we're not going to prosecute that policeman, we're going to defend him. That's right, we're going to defend him because he is a government officer, he's a government official. Now what does that tell you? Well, in our county, what it tells us is that the citizens are sitting over here being picked on one at a time by the government and prosecuted at their discretion and at their will. But when we, the citizens, want to prosecute one of those government officials for whatever cause, they will not prosecute him. And that's exactly correct. You see, we have to take that fellow to a grand jury. But you see what our problem is, we don't have any grand juries. Oh, now we've lost our grand juries, so the people of the state of Idaho are not prosecuting anybody, not to my knowledge. It's the state of Idaho that's prosecuting. Now, our Republican form of government is broken down because our jury system is broken down because we, the people, have not demanded that our jury system work. And so our democracy is working, but our Republican form of government is not. But you'll notice that the federal government will always indict you for tax evasion because, you see, in all courts of the United States, you have to have a grand jury. Because if you'll look at the words infamous crime and look them up in Bovier's, you'll find that an infamous crime is a felony. So anytime you're being charged for a felony, that's an infamous crime. And we're going to find as we read through these 2 cases here that as the felony is brought up, and the grand jury is brought in to give you the indictment, that an information really, in fact, is a political device used by government and has been for many years to harass and persecute citizens. And that's why you always want to demand a grand jury indictment. We'll get our grand juries back, but it's going to require a little effort on our part. They're not going to just give them back to us unless we scream like gut-shot banshees. So there in the Fifth Amendment, then, you'll find infamous crime, and you'll find no person shall be held to answer for said infamous crime except on presentment of an indictment. Not an information, troops, an indictment. The information is what you give to the grand jury. Now, if the prosecutor wants to give an information to the grand jury, that's fine. The grand jury will then decide whether or not to write up an indictment. But in our state, what they do is the prosecuting attorney writes up an information and he presents it to the court. The court hails you into the court and says, I have an information in front of me, Mr. Gordon, that you did thus and such. How do you plead? Well, I'm not going to plead to an information. Are you trying to cunningly coerce me into waiving my rights, Judge? I demand a grand jury. Where's the grand jury indictment? And what is the state of Idaho prosecuting me in this matter? Now, this is what Mackin said. They had prosecuted him without the indictment. So let's go on. So in the district court, the defendants were tried by a jury and convicted. A writ of error was sued out. Whether the crimes were infamous, whether the crimes had been tried or sent to a grand jury. And over here on page 350 then, here's Mr. Justice Gray, who's giving the opinion of the court. Paragraph 1. In Ex parte Wilson 114 U.S. 417, it was adjudged by this court upon full consideration that a crime punishable by imprisonment for a term of years at hard labor was an infamous crime within the meaning of the Fifth Amendment of the Constitution of the United States, which declares that, quote, no person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, and therefore could not be prosecuted by information in any court of the United States. Now there's the answer. You cannot be prosecuted by information in any court of the United States unless you grant them your permission. And that's what an information is. It's your permission to be prosecuted by an information instead of a grand jury indictment. And I'll get into that a little later. Over on page 351, the court went on. These are the highlights now of the case. The test is whether the crime is one for which the statutes authorize the court to award an infamous punishment. Notice the words infamous punishment now. Not infamous crime, but whether the court can award an infamous punishment. Not whether the punishment ultimately awarded is an infamous one. When the accused is in danger of being subjected to an infamous punishment, if convicted, he has the right to insist that he shall not be put upon his trial except on accusation of a grand jury. Accusation of a grand jury. Going on then, what punishments shall be considered as infamous may be affected by the changes of public opinion from one age to another. And for more than a century, imprisonment at hard labor in the state prison or penitentiary has been considered as infamous punishment in England and America. Now, if you're going to go to the state prison or you're going to a federal penitentiary, whether at hard labor or not at hard labor, as we're going to see later, that is called an infamous punishment. Infamous punishments are for infamous crimes, and that's 1 year and 1 day. If you're going to jail for a year and a day, it's time to start screaming for the grand jury. On page 352, down at the bottom of the page, how far a convict sentenced by a court of the United States to imprisonment in a state prison or penitentiary, and not in terms sentenced to hard labor, can be put to work, either as part of his punishment or as part of the discipline and treatment of the prison, was much discussed at the bar. So you see, whether or not it's at hard labor or not at hard labor was much discussed by these judges. But we have not found it necessary to dwell upon it because we cannot doubt that at the present day, imprisonment in a state prison or penitentiary with or without hard labor is an infamous punishment. Okay? Questions closed. Friend, if the charge is going to land you in jail for a year and a day, you have to be presented to a grand jury. All right, now, as we're going to find out, not every state is subjected to this federal standard. Now, just to fill you in on that for a moment, there's a number of cases that we're going to get into that show that the states don't have to give you a grand jury indictment because it's a state case. And I'm going to read you 3 or 4 of those. If the feds are going to do it to you, they will always give you a grand jury. So we don't have a problem with our federal government. We have a problem with our state governments that are putting us in jail or prosecuting us for these infamous crimes, subjecting us to infamous punishments, and not giving us our grand jury. Because when the states take away those rights, it subjects us then to trial by government, not trial by the people. Now, in Idaho, we're entitled to a grand jury or an information. And our state constitution so says in Article 1, Section 8. And that's one thing that you need to cover now. In your state constitution, find out what your state has to say about informations and indictments and grand juries, prosecuting attorneys, and public prosecutors, because those 5 items are going to be crucial when you walk into that courtroom with your motions and briefs. I'm afraid that if you walk in with a motion and brief and you say, I demand my grand jury, why the state has indicted me, or they've performed this information on me, and then they're going to bring up Hurtado versus California and say, well, that's only in federal courts. And that may be right, but it's time for us to start yelling like a bunch of banshees and getting that issue before the Supreme Court of the United States, and I'm going to show you how to do that as we go along. Turn over to page 354, down here at the bottom of the page, where we're talking about infamous crimes are thus, in the most explicit words, defined to be those punishable by imprisonment in the penitentiary. The result is that all the crimes charged against the defendants in this information are infamous crimes within the meaning of the Fifth Amendment of the Constitution, and that the defendants cannot be held to answer in the courts of the United States. Notice, courts of the United States, not courts of the state of Illinois or courts of the state of Idaho, for any of those crimes otherwise than on a presentment or indictment of a grand jury. And so says Macon. Now, did you notice in this Macon case, or Macon, I don't know how it's pronounced, it's M-A-C-K-I-N, that they referred to Ex parte Wilson? Now watch what happens. Here we are in 1885, and the court says, we decided in the Wilson case thus and such. Here again, the court didn't go off into a corner and take a secret ballot and decide, well, how do we want to rule on this case? They went to the law, just like in the Scripture it says, to the law and to the testimony. If they speak not according to this word, it's because there's no light in them. And so the judges of the Supreme Court, using that principle, say, to the law and to the testimony. What has gone before? This thing of a grand jury isn't something new. This comes from Magna Carta. And it's we, the people of the United States, when we formulated our Constitution.